Hello, my name is Neil Yarbrough and I'm the attorney for the North Carolina Auctioneer Licensing Board. On behalf of the board, I would like to welcome you to this seminar. As you know, the North Carolina Auctioneer Licensing Board is comprised of 5 members appointed by the governor. At least 3 of those members must be licensed auctioneers and at least 1 must not be. In addition to hiring an executive director and other employees, the commission has the following powers and duties. 1, to receive and review applications for licenses. 2, to issue licenses. 3, to deny, suspend, and revoke licenses. 4, to issue declaratory rulings. And 5, adopt rules for auctioneers and auctions. The board protects the public from incompetent or unqualified persons engaging in auctioneer activities. They are charged with preventing dishonest or negligent practices by auctioneers in the state. The board has an official mission statement which reads as follows. The mission of the North Carolina Auctioneer Licensing Board is to assure that the qualifications and activities of those engaged in auctioneering are in accord with the law and in the best interest of the public, to receive and act upon license applications, issue, suspend, or revoke licenses, adopt rules and regulations, and take such actions as may be necessary to enforce the laws that govern auctions and auctioneers. But a simpler way of saying that is this. The mission of the Auctioneer Licensing Board is to protect the integrity of the auction process for the benefit of the public and its licensees. This seminar is directed at meeting that goal and has been prompted by our experience in fielding questions from auctioneers and handling complaints about auctioneers. It has been our experience that the majority of the complaints received by the board against auctioneers are not the result of intentional wrongdoing, but oftentimes simply a result of an auctioneer not understanding his or her responsibilities or not taking the necessary precautions to protect themselves from complaints. The auction process, at least on sale day, is a real-time experience where actions happen quickly and the results have direct financial and sometimes emotional implications for the participants. The key to protecting your client's interest and the interest of your buying public, along with maintaining your license, is having a thorough knowledge of the process and the rules that regulate the process, planning, documentation, and follow-through. The North Carolina Auctioneer Licensing Board believes that it is so important for you to understand its rules that it has built in a required session on its laws and rules as a part of your ongoing continuing education. Before we begin a review of those laws and rules, to bring this point home clearly to you, I would like to provide you with a review of the disciplinary actions the board has taken in the last 4 or 5 years and the reasons for them. I believe, and I hope you will agree, that it's always better to learn by the mistakes of others than by your own. The first category shows that in the last several years, discipline has been rendered to licensees for acting as an auction firm without having an auction license. This problem typically arises when individually licensed auctioneers operate or act as an auction firm without having an auction firm license. The second category involves restricted business transactions for an auction house that were not performed by the appropriate person. In other words, the designated person. This problem typically arises when someone other than the designated person is involved in contract acquisition or some other activity for which only the designated person is authorized. The third category is a violation of the cardinal rule of auctioneering. Don't sell stuff without a written contract with the owner of the property to be sold. Although this is a simple and primary rule, it is amazing to see how many auctioneers have violated it. The fourth category is also a significant problem about an intake issue, which usually only causes a problem after the sale when there is a controversy about the proceeds, what was delivered for sale, and what was actually sold. The fifth category is the back end of the record-keeping problem we just discussed above, and failures to keep accurate sales records typically not only leads to a complaint, but sometimes results in litigation. Of course, if you fail to intake the property accurately, as described in Category 4, it is hard to maintain good sales records. The sixth category, as you may have guessed, is the largest source of complaints, and that deals with how you handle your client's money. We will discuss this problem as well as others in greater detail later on. The problems associated with the seventh category typically reveal themselves during the investigative process of a complaint filed for another reason. Keeping good records and providing them to the staff members of the Commission is important not only in defense or explanation of other complaints, but also to prevent discipline for the violation of this rule standing alone. It has actually happened that the primary complaint has been resolved, but some minor form of discipline occurred due to the availability to the staff of good records from the auctioneer. The eighth category is an add-on charge which sometimes accompanies specific serious charges that typically result in significant disciplinary action. The ninth category is basically a fraud charge, and violation of this provision will typically result in revocation. The 10th category oftentimes is simply a follow-through problem where there may be a complication in the accounting or lack of interest after the excitement of the sale by the auctioneer, with the auctioneer failing to act promptly. It is important to note that sometimes there are disputes between the owner and the auctioneer or others associated with the sale, which can legitimately delay the payment of funds. This is in and of itself not a problem if an accounting of the funds with an explanation of the problem is provided to the seller on a timely basis. In other words, just because there is a problem that may delay your ability to pay out money to the seller, you should at least let the seller know where the money is and what are the competing claims on that money. The 11th category is fairly self-explanatory, and discipline typically occurs involving advertisements for absolute auctions which don't turn out to be absolute. The 12th category typically is an add-on charge which accompanies other serious charges resulting in significant discipline. When I refer to the term add-on charge, I'm not saying that the Commission is piling on, but sometimes it's necessary in complicated and egregious fact situations to utilize a variety of charges to fully capture the essence of the wrongdoing. The 13th category of violation sometimes can result from innocent mistakes or be the result of dishonesty. Always pay particular attention to handling of other people's money. The 14th category results in the failure to promptly or timely transmit necessary information to the North Carolina Auctioneer Licensing Board or its staff. Sometimes this charge arises from the course of investigation of complaints related to other violations. The last category of recent discipline typically arises from a failure of the auctioneer to pay expenses related to the auction process to third parties. One concern being that if an auctioneer is stretched out too far on his or her own debts, they may be tempted to dip into the client's funds. Another concern is simply that the reputation and integrity of auctioneers and the auction process in North Carolina is at stake. As a side note, this provision is one of the most often used sections of the Auctioneer Licensing Board to deny initial licensing. For example, if an applicant has unpaid judgments or liens, it is most unlikely that he or she will be licensed until those debts are resolved. Also, please remember, if you get notice of a complaint, respond in a timely and complete fashion. We have had cases where the complainant's initial description of the problem did not rise to a regulatory violation, but the auctioneer failed to respond to our investigative inquiry. The auctioneer's license was ultimately revoked due to his failure to cooperate with the investigation, even though the problem initially stated by the complainant would not have resulted in discipline. Please respond if you get an investigative inquiry. Now that we have reviewed the errors of the past, let's look at the law to prevent future problems. The key to starting the auction process is similar to the recipe for Rebel Rabbit Stew. First, you get yourself a rabbit. In other words, the beginning step in any auction process is obtaining the contractual right to sell land or goods for the owner of that land or goods. This right must be accompanied in writing between the auctioneer and the property owner and must describe the terms and conditions upon which the auctioneer received the goods for sale. As an attorney, I'm a great believer in the premise that good contracts make for good relationships, and it's been my experience that addressing certain details in writing in advance and in the honeymoon stage of the relationship eliminates a lot of the problems at the tail end of a sale. Some of the items which should be addressed in the owner-auctioneer contract are the auctioneer's fees and expenses, a detailed description of the goods to be sold, a time frame of the sale and the duration of the contract, including any post-auction listing tales for any items not sold at auction, the terms of sale, absolute, minimum bid, subject to liens, etc., the proposed location of the sale, responsibility for delivery of goods, deposit requirements and payment schedules, and owner-auctioneer split of any forfeited deposits. In addition to your owner-auctioneer contract, you need to have good buyer contracts which mirror the terms of the sale included in your owner-auctioneer contract and other relevant provisions. Sometimes in personal property sales, there are not actual written contracts with buyers, and the terms of the sale as between the auctioneer and the audience are established by announcement or providing the audience with a list of purchase terms. In any event, you should have in writing and available to buyers at your auction the terms of sale. This greatly reduces the chances of a he said, she said controversy at payment or pickup time. Typically, the terms of sale are handed out at the time buyers register and on the registration sheet. There should be a signed buyer affirmation that the buyer has received the terms of sale. Complaints about sales day activities of auctioneers could greatly be reduced by appropriate documentation of the terms of sale. Of course, when you're selling real estate, the terms of the contract usually become a little more complicated, but there are many standard forms available which address most contractual issues related to real estate transactions. Also, when you are selling real estate, you should be aware of any additional forms which may be required or at least beneficial, such as residential disclosure statements, lead-based paint notices, and the provision of any relevant restrictive covenants. A surefire way of getting into trouble with your clients and the licensing board is the auctioneer's failure to properly handle money which is not theirs. Sometimes these are minor bookkeeping or clerical errors and resolved with little discomfort, delay, or confusion. But when actual misuse of a client's funds is involved, the results can be very threatening to the auctioneer's reputation, finances, license, and even his or her freedom from incarceration. There are specific statutory requirements for how you handle a client's funds. If you're not going to disperse the sales proceeds on the day of the sale to the seller, you must place the sales proceeds or any earnest money deposits in your trust account. Prior to disbursement or at the time of disbursement, you must provide the seller with a settlement statement which includes the following. 1. A description of all goods sold. 2. The selling price of the goods sold. 3. The net proceeds due to the seller or consignor. 4. The name and address of the person receiving the disbursement. And 5. The amount of the disbursement. All settlement statements shall be signed by the licensee or the licensee's agent and by the person receiving the disbursement. This is a very important point. One problem we have noticed regarding signed settlement statements is a common auctioneer practice of mailing 2 copies of a settlement statement to a client along with their check, with a request to review and sign the settlement statement and to mail it back to the auctioneer, sometimes with a self-addressed stamped envelope enclosed. This may be a convenient way of handling your obligations under North Carolina General Statute 85B7, but it is a risky one. As you know, North Carolina General Statute 85B requires all auctioneers to have all settlement statements signed by the licensee or the licensee's agent and by the person receiving the disbursement. This statutory requirement not only protects the public, but it may also protect the auctioneers from after-the-fact complaints about sales prices, commission percentages, additional costs charged, and other matters. Furthermore, if a complaint is filed against you regarding a dispute on a sale, one of the first items requested by the investigator will be a copy of the signed settlement statement, and failure to produce one is a violation in and of itself, regardless of the merit of the original complaint. As a practical matter, if the seller is going to dispute your services or the money split, you need to know this as soon as possible, before the dispute becomes a legal controversy. Therefore, my suggestion to auctioneers is if you are not going to have a face-to-face exchange of the signed settlement statement and the proceeds check, you need to write a letter to your seller that goes something like this. Enclosed, you will find 2 copies of your settlement statement reflecting the accounting for the sale you hired me to conduct, and a copy of my escrow account check to you in the amount of whatever, which are your net proceeds as reflected in the settlement statement. Please review the settlement statement. If it's correct, sign one of them and mail it back to me in the closed, self-addressed, stamped envelope, and I will immediately mail you your check. This language may sound a little legalistic for your taste, and you may want to adopt it to your own style of communication. However, words to that effect, along with this practice, will help prevent a complaint to the North Carolina Auctioneer Licensing Board and perhaps a lawsuit by your client. To send the actual check with the settlement statement sets you up for at least 2 problems. A well-intentioned seller who, after they receive their check, may develop little interest in doing anything further related to the sale to assist you, or 2. A less well-intentioned seller who may take your check, cash it, and then complain about the transaction. In either of these 2 events, if the board learns of your failure to comply with the signed settlement requirement, you may be subject to some form of license discipline. Of course, if litigation arises, having a canceled check may help you, but it is not as good as having a canceled check and a signed settlement statement. In assessing this course of action, you may consider the effect of the statute which requires auctioneers to account for or to pay over within a reasonable time, not to exceed 30 days, funds belonging to another which have come into the licensee's possession through an auction sale. It is my position that sending the settlement statement within the 30 days complies with the account for compliance alternative to that statute. Obviously, the quicker you can begin this process, the smoother it will go. In another situation, sometimes when the sale is not consummated, a dispute arises as to the distribution of any escrowed funds as between the seller and the buyer. Hopefully there will not be any disputes between the seller and you as the seller's auctioneer, in that you have previously addressed those issues in your contract with the seller. The vast majority of times that a dispute arises regarding escrowed money, it is in a real estate transaction. These failures to close come from a variety of sources: a defect in title, a failure to obtain necessary funding, buyer's remorse, seller's remorse, or a variety of other reasons. As the escrow agent, it is not your job to determine who gets what, but you can only release the funds when such a situation arises, when both parties agree in writing or you receive a court order from a court of competent jurisdiction directing you to disperse in a particular manner. In the meantime, you must maintain your role as a relatively neutral stakeholder, regardless of your personal feelings or self-interest. Sometimes this causes problems for the auctioneer when the parties simply lapse into a do-nothing attitude and the matter lingers on. In those circumstances, you should certainly be proactive in trying to get some decision made, and at the bare minimum, keeping both parties familiar with the status of the funds held in trust by you. There are other things that you should also keep in mind relating to your escrow account. For example, if you are in-state or out-of-state, you will need to keep your money in a bank that is authorized to do business in North Carolina. There are no specific licensing board regulations regarding how the accounts are set up. Reference to the Real Estate Commission's rules on trust accounts may also be necessary if you are a real estate broker or simply helpful to you as a go-by. There is a special section on their webpage for trust account guidelines. Additionally, the North Carolina State Bar has numerous publications regarding how attorneys handle client funds, which can be assistance to auctioneers as a go-by. Proper handling of client funds and proper documentation of how you handle client funds is critical to your career in auctioneering. Good record keeping is a key to defending lawsuits or licensing board challenges to your conduct as an auctioneer. However, before you can keep good records, you must develop good records. Providing clear documentation of your prior activities when you receive a complaint from the board investigator is a good way to turn a time-consuming, expensive, embarrassing, and license-threatening investigation into a 3-sentence response letter which includes the words, "See documents attached." Please remember, it is not only important that you have done the right thing, it is important that you can prove that you have done the right thing. As you may imagine from my previous statements regarding handling client funds, trust account records are some of the most important forms of documentation. The auctioneer licensing statute requires that complete records showing the deposit, maintenance, and withdrawal of trust funds be maintained for 5 years. This 5-year requirement also relates to your disbursement of funds on the day of the sale, even if they do not go into your trust account. Sale day disbursements must include a copy of each receipt or settlement statement issued at the time the funds are disbursed. The Commission has the authority to review your trust account records without prior notice, with or without a complaint being filed against you. Therefore, keep your trust records straight at all times. Contract record keeping is also the subject of statutory regulation. Each licensee is required to keep a copy of the fully executed auctioneer contract for his own records for 2 years after the date of the agreement. Copies of all contracts shall be made available to representatives of the Commission upon request. Developing good records is a key part of your pre-sale day activities as an auctioneer. Many of our complaints arise from accusations that the auctioneer did not pay the owner for the goods he had sold. This is usually the case with small knick-knack items which suddenly become family heirlooms or art objects. If you don't have a good record of what you received from an owner for the sale, it is impossible later on to accurately account for the sale's proceeds. Again, many of our complaints arise from what we might call box lots, or simply large number of small value items which suddenly take on increased worth if misplaced. Try your best to itemize small items in your intake paperwork, if by no other method by description of similar items such as a 20-piece assorted set of stainless steel dinnerware, 12 wool blankets, or other measure. Another way to further protect yourself, particularly in this digital age, is to simply take pictures of the items or the group of items as they come in and then download those pictures into your computer for future reference. A picture being worth 1,000 words, sometimes a good picture puts an end to such a controversy. Also, good intake record keeping and a reputation for good intake record keeping is a good way of cutting down on possible employee theft when items are stored over time or moved from place to place. Once you have good intake records, recording sales is much easier, but it is still very important to do so in a clear manner. It is the second half of the money trail. As shown in these slides, you have a statutory responsibility not only to develop these records, but to maintain them and make them open for inspection to the board's investigators. Another form of protection for you is to have printed announcements of the terms of sale. Oftentimes we receive complaints about what the auctioneer said or didn't say about how the sale was to be conducted, and a written copy of the sale terms announcements would have pretty much resolved the issue. For example, our regulations require that at all auctions that include buyer's premiums, that the amount of the buyer's premium shall be announced at the beginning of the auction, and a written notice of this information shall be conspicuously displayed or distributed to the public at the auction site. Under the heading, Things Not to Do, in a response we recently received to a complaint regarding terms of sale, all we received was a handwritten summary of what the auctioneer thought he remembered that he announced. Obviously, once a complaint is filed, that type of after-the-fact reconstruction doesn't carry as much weight as a printed term sheet and announcement, which was broadly disseminated on the date of sale prior to the auction. Another excellent tool for record keeping and auctioneer protection is video recording the sale, including pre-sale announcements.
There's many reasons you might need to have an auction. You may need to retire, settle an estate, divide a partnership, or just sell some unneeded or surplus assets. Now let me go over the terms and conditions for the auction today. We have about 10 of these right here. This is the terms and conditions, and these are pasted around in any number of places here today. And if you want one of them to take home with you, please feel free to do so. And I'm going to read that to you now.
This videotape or DVD can very quickly clear up any controversies that may arise about what was said or not said or done or not done at an auction. It is also an excellent self-improvement tool for the auctioneer to review his performance from time to time, and with the advent of cheap video equipment and the recorded media, it is very easy and inexpensive to set up a camera on a tripod and let it run during the course of the sale. Again, some of these record-keeping requirements are mandatory, but some of the documentation techniques that I have just mentioned are just good ways to protect yourself from complaints and lawsuits. There are several events in an auctioneer's career that require reporting. They involve changes of address, change in business relationship, and notification of lawsuits or criminal charges. On occasion, auctioneers forget or otherwise fail to make these notifications to the licensing board. Failure to do so in any circumstance can result in disciplinary action, with the failure to report lawsuits or criminal charges being the most problematic for you. In a recent complaint, no discipline was given regarding the original basis of the complaint, but during the investigation, it was discovered that the auctioneer had changed his place of business without notifying the board. Even after contact with our investigator, the auctioneer did not update his business information, and minor discipline for that violation was imposed. The reporting requirements are contained in section .0601 and .0405 of our rules and are as follows. All licensees shall notify the board in writing of each change or addition of residence or business address, including mailing address, and change of trade name, assumed names, or combination of names under which the licensee conducts business related to auctions. For corporate licensees, a change in directors or officers require reporting. For partnership licensees, changes in partnerships require reporting. For an auctioneer firm licensee, a change in the designated person requires reporting. All changes, address, name, ownership, etc., must be reported within 10 days. There are other types of reporting to which you should pay particular attention. All criminal arrests or charges, any convictions of any misdemeanor involving dishonesty, deceit, fraud, or misrepresentation, convictions of any felony. Convictions include verdicts of guilty, pleas of guilty, and nolo contendere pleas. Notice must be given in writing within 30 days of each of those types of occurrences. Civil lawsuits involving any allegation of gross negligence, dishonesty, fraud, misrepresentation, or incompetency, or that in any manner relates to auctioneering, must be reported. Any administrative procedures which involve any potential revocation, suspension, or disciplinary action against any licensee in another state must be reported. Notice must be given in writing within 30 days of each occurrence. Typically, the North Carolina Real Estate Commission will notify us of any real estate complaints against auctioneers. We receive a large number of complaints relating to absolute auctions. Of course, we investigate those complaints, but in addition, programs are sometimes implemented to simply review every owner-auctioneer contract where our investigators observe absolute auction advertisements. If you are going to advertise an auction as absolute, it must be absolute with no ifs, ands, or buts. The statutory definition is absolute auction means the sale of real or personal property at auction in which the item offered for auction is sold to the highest bidder without reserve, without the requirement of any minimum bid, and without competing bids of any type by the owner or the agent of the owner or of the owner of the property. In addition to any fraud allegations which may accompany an auction that is advertised as absolute and doesn't turn out to be so, there is a specific board regulation which prohibits such activities. It shall be a violation of these rules to advertise an item, either real or personal, as absolute or without reserve if the item is subject to confirmation, minimum bid, or any other condition of sale. People very easily understand the concept of subject to confirmation or minimum bid, but sometimes it's the other conditions of sale that trip up the auctioneer. For example, it is not an absolute auction to sell a piece of property which is subject to a mortgage or lien. In other words, the encumbrance sets a purchase price floor as firmly as a minimum bid requirement. Therefore, be careful in checking out the background of any item to be sold or the motivation of a seller for an absolute auction. Typically, the way an auctioneer runs into an absolute auction problem is through the advertisement process. You cannot advertise an item, either real or personal, as absolute or without reserve if the item is subject to confirmation, minimum bid, or any other condition of sale. Before you advertise an auction event as an absolute auction, the majority of the items must be offered for sale as absolute or without reserve. Items that are not absolute may be included in the auction provided they are specifically designated in all announcements or advertisements. Although not necessarily classified as an absolute auction, there are other similar of what I call blood in the water type auction advertisements, which are also subject to complaints. These advertisements are designed to draw in potential bidders with the lure of a distressed seller. In these circumstances, if you're going to make such advertisements, make sure they accurately describe the nature of the sale. There are similar rules in the sections .0602 related to bankruptcy sales and estate sales. Also, there are specific rules that relate to using such terms as urgent, emergency, distressed, seized, confiscated, forfeited, or similar type words unless the sales meet the legal requirements of such terms and specific language is added in the advertisement. Another area where auctioneers can run afoul of the absolute auction rules is in the bidding process, and the board has rules to govern those. Care should be given in the bidding process to make sure closely related parties to the owner or auctioneer are not bidding. In other words, no straw men. A minimum bid is not required in an absolute auction. In a sale with reserve, the auctioneer may bid on the reserve item up to and including the amount of the reserve price without the intent to purchase the item, if such auctioneer option is announced in advance of the auction. Another area of concern with absolute auctions has arisen when a large item, typically real estate, is advertised for sale by absolute auction, and before the matter is offered for sale, the auction is canceled or the item is withdrawn prior to sale. There are sometimes legitimate reasons for cancellation, but they typically result in a group of dissatisfied potential buyers who have arranged their day around the auction, driven many miles, or made other personal or business adjustments based on the proposed absolute auction sale. At best, it will cause dissatisfaction and hard feelings. At worst, it will result in a complaint and possible disciplinary action. Although these canceled sales complaints require a factually intensive investigation, it could result in discipline under at least 3 different regulations. Number 1, it shall be a violation of these rules to advertise for sale items which the auctioneer does not intend to offer for sale at the advertised auction. Secondly, a continued and flagrant course of misrepresentation can be a violation. And lastly, any false, misleading, or untruthful advertising could result in discipline. Very few things bring the auction process into such widespread disrepute as advertisements which draw a small or large crowd based on specific representations, and then they turn out not to be true and the auction does not occur or does not proceed as advertised. Finally, there are some other pre-sale day activities to which auctioneers need to pay particular attention. The first one is at the listing contract negotiation phase with the owner of the goods to be sold. Auctioneers should be careful to explain to sellers the reality of selling land or personal property at an absolute auction. Many sellers with stars in their eyes about the value of their property think absolute auctions are the way to go. but are disappointed by the final sales price and then file complaints against the auctioneer, or worse, file lawsuits against the auctioneer. Be sure your client has a good understanding of the pluses and minuses of an absolute auction. Client education and setting appropriate expectations are great ways of preventing complaints and lawsuits. Additionally, as a risk management tool, develop a letter to document your advice. Another pre-sale date matter which you should concern yourself is your due diligence in checking the title to property that is for sale at absolute auction to make sure there are no deeds of trust, security interest, or liens which could create a minimum price for the purchaser to obtain clear title at the sale, therefore avoiding the idea that it's an absolute auction. Checking ownership rights are also important in auctions that are not absolute to avoid customer dissatisfaction or post-sale problems. On a related topic, in many instances, sellers employ auctioneers because they are in financial trouble and need to liquidate certain assets. Whether the sale is absolute or with reserve, you should exercise some diligence in alerting potential buyers as to the conditions of sale relating to liens or encumbrances. If there are any warranties of title, say so. If there are not, be sure to make that clear. Finally, you should exercise some caution to make sure you are not intentionally injuring third-party lien holders, creditors, or individuals with possible competing ownership interest in the items to be sold. We often receive complaints that relate to auction firm regulations. The majority of these complaints concern individual auctioneers who should hold an auction firm license or auctioneers who enter into an agreement with third parties which create an auction firm relationship without the benefit of appropriate licensure. The statutory definition of an auction firm is a sole proprietorship of which the owner is not a licensed auctioneer or any partnership, association, or corporation not otherwise exempt from this chapter that sells either directly or through agents, real or personal property at auction, or that arranges, sponsors, manages, conducts, or advertises auctions, or that in the regular course of business uses or allows the use of its facilities for auctions. The definition applies whether or not an owner or officer of the business acts as an auctioneer. A designated person means any person approved by the board to have the authority to transact business for a licensed auction firm. Furthermore, it is not necessary to hold an individual auction license to be a designated person, but you must go through the designated person approval process with the North Carolina Auctioneer Licensing Board and be so approved before conducting business as an auction firm. A non-auction firm business means a sole licensed auctioneer whose business is not defined as an auction firm as set forth in General Statute 85B 1-6. Basically, a non-auction firm business is an individually licensed auctioneer. If you hold an individual license and do not operate in an auction firm context, particular care should be used in associating other individually licensed auctioneers to do portions of your auctioneer functions. For example, you can only have them bid call or act as a ringman if you are on the premises and controlling the other aspects of the auction process. The board has further issued the following interpretation regarding auction firms. 1. Only designated persons for an auction firm have the authority to transact business under the firm license. This includes arranging, managing, soliciting, and contracting auctions, the supervision of the auction staff, the supervision of the acceptance of consignments of items for sale at auction, the supervision of the advertising of an auction, and the supervision of the acceptance of payment and the disbursement of monies for items sold at auction. Number 2, at least one designated person shall be on premises of an auction firm's auction sales location while the auction sale is conducted. 3, a licensed auctioneer who owns and operates a non-auction firm business has the sole responsibility for arranging, managing, soliciting, and contracting auctions, the supervision of the auction staff, the supervision of the acceptance of consignments of items for the sale at auction, the supervision of the advertisement of an auction, and the supervision of the acceptance and the disbursement of money for items sold at auction. 4, a licensed auctioneer who is employed or contracted by another licensed auctioneer who owns and operates a non-auction firm business can only be responsible for calling bids and performing duties that a non-auctioneer is allowed. 5, a licensed auctioneer who owns and operates a non-auction firm business shall be on the premises of his business auction sale while the auction sale is conducted. There are other laws which affect your practice as an auctioneer outside of our licensing laws. The 3 primary ones are North Carolina's real estate laws, the Uniform Commercial Code, and North Carolina's Unfair and Deceptive Trade Practices Act. Looking at our real estate laws, they involve licensing, the statute of frauds, liens, deeds of trust, and estates issues. An example of a real estate law which can affect auctioneers is the statute of frauds. This law dictates that all real estate contracts must be in writing and signed by the party to be charged. A lot of people don't know this, but there is actually a North Carolina statute of frauds. It is North Carolina General Statute 22-2. Under the Uniform Commercial Code, we have Article 2 that covers sales, Article 3 relating to negotiable instruments, and Article 9, secured transactions. Because auctioneers are involved in commerce on a daily basis, there are several provisions that deal directly with auctioneering and many others which are indirectly involved. Chapter 75, our Unfair and Deceptive Trade Practices Act, also provides certain influences on how you should conduct your activities as an auctioneer. The North Carolina Supreme Court has held that a violation of a statutory provision designed to protect the consuming public, such as Chapter 85B, may result in an unfair and deceptive trade practice as a matter of law if the violation offends established public policy or is immoral, unethical, oppressive, unscrupulous, or substantially injurious to consumers. This statement of law comes from a recent appellate decision regarding a case where secured creditors were suing an auction company for, among other things, allegedly improperly dispersing sales proceeds. The ruling in this case illustrates the interplay between the board's statutes and regulations and a lawsuit by dissatisfied customers or third parties against an auctioneer. In other words, if you get sued as an auctioneer by some party associated with an auction sale or your conduct as an auctioneer, it is very likely that the first thing a plaintiff's attorney is going to refer to is North Carolina General Statute Chapter 85B and the regulations promulgated thereunder to determine whether you have violated any of the licensing laws for auctioneers. On the other side of that coin, evidence by you that you have complied with the North Carolina Auctioneer Licensing Board's laws and regulations may provide you with an adequate defense, at least to some aspects of a plaintiff's complaint. Nonetheless, It is more than likely that if a dissatisfied party to one of your auctioneering activities sues you, they are also going to file a complaint with the North Carolina Auctioneer Licensing Board to go after your license. Furthermore, if they don't, you are still required by Section .0405B of the Board's Rules and Regulations to report to the Board any and all civil suits involving you that are based upon any allegation of gross negligence, dishonesty, fraud, misrepresentation, or incompetency, or that in any way involve an auction sale or a transaction related to an auction matter or auctioneering within 30 days of the date of the complaint is served on you. As there are other laws that impact the auction business, there are other regulators and regulations which you, as an auctioneer, will encounter from time to time. Many of you hold real estate broker licenses, and if you don't, you need to thoroughly familiarize yourself with North Carolina's real estate licensing laws before considering an auction sale of real estate in North Carolina. You will also need to associate people who are properly licensed to do that. There are also certain activities which are governed by other agencies. These agencies provide exemptions under our laws but requirements under theirs. For example, sale of livestock at a public livestock market authorized and regulated by the Commissioner of Agriculture is exempt from our regulations. Sale at auctions of automobiles conducted under the provisions of North Carolina General Statute 20-77 or sale at an auction of motor vehicles by a motor vehicle dealer licensed under Article 12, Chapter 20 of the North Carolina General Statutes is also exempt. Finally, a sale at auction of a particular breed of livestock conducted by an auctioneer who specializes in the sale of that breed, when such sale is conducted under the auspices of a livestock trade association, is exempt, provided that the sale is regulated by the Packers and Stockyards Act and the auctioneer is required to be bonded by the United States Department of Agriculture. Please note, the exemption regarding livestock does not extend to the sale of tack, or in other words, saddles, bridles, that type of thing, or other livestock-related items of personal property. An auctioneer license is still required to sell these types of items, even if they are done in conjunction with a livestock auction. Similarly, the exemption regarding automobiles does not apply to the sale of automotive parts or other automotive-related products. An auctioneer license is still required to sell these items, even if done in conjunction with a motor vehicle auction. Frequently, as an auctioneer, you are called upon to sell guns, and before you do so, if you do not hold a federal firearm dealer's license, you should contact your local ATF agency to inform them of the sale and ask for their advice. The interpretation and enforcement of firearm sales at auctions by the ATF sometimes varies from region to region, but ATF agents statewide have a reputation for being helpful in providing advice and counsel before a sale is actually held in what you need to do. Likewise, you are sometimes asked to sell alcoholic beverages at auctions. There is a one-day permitting process with the State Alcoholic Beverage Control Commission, which you should apply for directly through the Raleigh office if you propose to sell alcohol by auction. The following is a list of agencies that you should contact from time to time regarding various items that you may be selling. Contacting these agencies or other miscellaneous agencies which may have regulatory control of the subject matter of your auctions before the sale can save you months of hassle thereafter if you have not done something correctly. The North Carolina Auctioneer Licensing Board wants to protect the public you serve, and the best way to do so is to help you become a better auctioneer. It is impossible in this limited time to address all the legal issues that affect you as an auctioneer, but we hope that this seminar has helped to sensitize you to some of the legal issues involved in your profession so that you may better serve your clients and customers and better protect yourself from complaints and claims. A few final words of advice that may assist you are these. Participate in your professional organization. Keep good records. Make adequate disclosures. Think about what you're doing. Any questions? Confer with your attorney. Call the board before taking matters into your own hands. Promptly respond to and cooperate with board investigations. Report any criminal or civil actions against you immediately. And check the board's website for updates. In conclusion, I'd like to wish you good luck and good auctioneering.